Whether the name on a search warrant is public by law is now before the South Dakota Supreme Court. Attorneys for two news organizations say that South Dakota law is clear and that search warrants are public record. However, the attorney for the person at the center of this conflict claims that his client was incorrectly listed as a defendant, and therefore the name should not be unsealed. KELOLAND's Angela Kennedy breaks down this complicated case.
Under current state law, judges are allowed to keep certain items secret or sealed from public view. But the law also says the information surrounding a search warrant cannot be kept secret. The news organizations are asking for records relating to search warrants issued to someone who has only been identified as an implicated individual. Because of a gag order, KELOLAND News was unable to get anyone involved in this case to confirm or deny that individual's identity. Therefore, we are not releasing it until the court would order it to be unsealed.
Mr. Chief Justice.
Former South Dakota Attorney General Marty Jackley is representing the unnamed individual. He says that person was incorrectly listed as a defendant. Jackley says the Supreme Court has the authority to order that the file remains sealed and to order that identifying information be removed or redacted to protect the person.
You have before you an uncharged individual that's never been arrested, there's never been a complaint filed, an information, or an indictment. That the state that applied for the search warrant has openly admitted the search warrant is an error and that it refers to the individual as a defendant in a criminal case. The facts further are that this investigation has not been officially terminated and that the trial court initially accepted the state's request to seal the search warrant documentation.
Attorneys for ProPublica and the Argus Leader argued before the court that a state law must be followed, which bans judges in most instances from sealing search warrant information.
We have a statute that's pretty clear, and it says this stuff is going to be open. The public has a right of access to it.
This is a citizen saying, I want my name removed from it because it's embarrassing. And if we go down that path, essentially the floodgates are going to open. The more absurd result that's going to happen is you're going to have every criminal defendant going to want to seal all these records for anything that they think is embarrassing.
The Supreme Court will issue its decision in this case at a later date. KELOLAND News will continue to follow this case and will let you know when there is a ruling and whether or not the name or information related to the search warrant will be released.